happy to be with you. My name is Ali Talai. I'm a trust and estate planning attorney, and I look forward to going over some of the estate planning options that become essential if you are not married, but you have a partner and you decided that, what kind of estate planning documents you need to have in place. So this video, protecting your partner, we're going to be talking about that. Give you a little background about myself. I am a estate planning attorney. I have an advanced tax degree with a certificate in estate planning. The focus of our law firm is to do estate planning for individuals that are looking to really have a customized estate plan, asset protection planning, estate tax planning, trust administration, probate, and realistically everything to do with estate planning. That's our goal. I do have a radio show, a weekly radio show on 670 AM. It is in Farsi, so if you cannot speak Farsi or you don't understand it, then maybe this is the place to be. I'm happy to be talking with you. If you're on YouTube, please do me a favor, give us a like. You could follow us. And we are on other social media platforms as well, Instagram, LinkedIn, Facebook. And so if you are looking to get more information on an almost daily basis, please follow us there. And with that said, let's talk about why should you care about financial and estate planning matters if you have a partner. These days, it's a much higher percentage than what it used to be. There are lots of couples that are together, they've been together for a long time, and for some reason, good or bad, I'm not sure, but for some reason, there is a higher percentage of couples that are living together and are not married. So when we're talking about estate planning, that could make an effect if you don't do anything because the law is not on your side. And if unfortunately something happened, you or your partner becomes incapacitated, or unfortunately somebody passes away, then there could be consequences in estate planning or with the assets that you have that was not what you were thinking, or at least that was not your intention. You wanted to provide for your spouse. You wanted to provide for your partner. You wanted your partner to be able to have more decision in what would happen to you. And that's why having the right estate plan in place becomes essential. So if you don't have a plan, what happens, you fall on the sort of the backup plan that every state has. So every state has these laws they call intestacy laws, and it's really a will that they've prepared for you. You could opt out. You could do your own estate planning, which I would, in most cases recommend. And if you have done no estate planning and you're falling back on the intestacy statutes, it says that the surviving spouse would realistically be on as number one. Then you have descendants. If you have no estate plan in place and we're trying to figure out who would inherit your asset, then it's usually surviving spouse. We're in California, so if it's community property, the entire estate will go to the surviving spouse. If it's separate property, then it could be a division between the surviving spouse and descendants. But in this case, let's just say, it's just community property, then it will just go to the surviving spouse, descendants, parents, siblings, nieces and nephews, and further down. But if you're not married, then there is no community property statute. There is no, it's not recognized as a community property. So if you own a property under your name, or it's your portion of the property, and you have children from a previous marriage, then your partner, if you pass away, have not done any planning, everything will go to your kids, which might be something that you wanted to do anyways, but maybe that was the plan that eventually at some point that would happen, that maybe the plan is that a portion of it or all of it is left for your partner. And then when your partner passes away, at that point, what's left will go to your children. So I want to start with kind of letting you know what the default is, and then we'll go through it and talk about some of the plannings that we could do. As you could see, there's no mention of a partner. There is nothing that would go to your partner, no decisions, no assets or anything like that. These days, we have a sort of a different blended families. One thing you're used to hearing blended families is that spouses are married, had previous marriages, had children from previous marriages, and now um, that becomes, your normal blended family. And usually the new spouse has priority over money and property, with children potentially being disinherited, especially again, if it's all community property and you're married to somebody else, it'll all go to the surviving spouse. The This option, if you're not married and you and your partner are in a relationship, if something happens, one of the partners pass away, the partner has no priority, and it's really the children that have the initial priority as far as who would inherit your estate. Federal tax issues. Let's talk about that. The IRS. So if you got a large estate, so that this is the federal state tax issues, and federal tax issues usually are essential if you have a larger estate. And if you're not married and you and your partner, then it becomes important to have these in mind as well. If you're married and U.S. citizen, you can give an unlimited amount to each other during life. You could give your spouse 10 million, 100 million, or more. Again, good problems to have, but as far as gift taxes goes, there's no gift tax. You can leave an unlimited amount to each other at death, and there's no issue either. Spouses would have to be citizens for this rule to apply. If you are unmarried and your partner is a U.S. citizen, you can give them a $17,000 gift in 2023, and then you could only give them $12,920,000 for year 2023. Unfortunately, one of the partners passes away this year. That's the limit. There's no unlimited. I mean, this 12.9 it's a large amount, and again, smaller percentage of people, fewer percentage of people have this sort of issues. But if you have a large state, then this becomes problematic. And then this exemption at 12,920,000 is set to sunset in about 2 years, and it'll be approximately about $6.5–7 million. All right, personal matters. What I mean by personal matters is who can handle your financial situations, medical decisions, and all those sort of things. And if you don't get to choose, if you don't choose who you want to handle these things, and again, if you want your partner to be, and you don't do a healthcare directive, you don't have a financial power of attorney, what happens, a judge will get to make that decision for you. Judges, especially here in California and Los Angeles, we have really good judges, but one thing is that they don't know your family, they don't know your situation. So it's always best to have those decisions made. We would make those decisions instead of leaving it for someone else to make those decisions for us. Financially protecting your partner. Let's talk about that. So these are now some of the solutions. These solutions are just one of the kind of solution. I'm not saying these are the best. In most cases, I wouldn't want to set it up this way anyways, but my goal here is to just kind of give you some ideas, let you know how these things could be set up. One is that you could have accounts or properties, you could hold them as joint owners. Let's talk about, let's say, a house. If you own a house, you could add your partner's name to it, and it could be partner one and partner two as joint tenants. And how joint tenancy works is that when one partner passes away, his or her share would automatically pass along to the second partner without needing to go to court. So then this would take care of at least the other partner to a certain extent. There's some issues with it with joint tenancy. If one partner becomes incapacitated, then there would be a need to go to probate court, because the other partner, even if they were married, they couldn't make decisions or act on behalf of the other partner or the other spouse. So pros: easy to do, minimal or no cost, and there's no court involvement at the time one of the partners passes away. There'll be court involvement when the second partner passes away, because then there's nobody is named on the property. Cons: partner chooses, your partner gets to choose who gets the property at their death. So if it's your house, you add your partner's name to it, you pass away first, Your partner gets 100% of the property, and he or she could just decide that they're going to give the house to their family member and disinherit your kids. The other problem with these sort of planning is that now that property is vulnerable to your partner's creditor as well. So again, probably not the best planning, but it's a plan. Naming your partner on your retirement account and life insurance as beneficiary designation form. And again, easy to do, no cost, usually no court involvement at your death. You maintain control while you're alive. Cons: accounts or funds are vulnerable to your partner's creditor. Partner chooses who gets the remaining amount, and no control over how the money is being spent. A solution, and it may be, doing something sometimes is better than doing nothing, but again, probably not the best solution. Then the other one is transfer on death accounts or beneficiaries. Sometimes they call them pay on death accounts, pay on death beneficiary. And you see these more often with bank accounts. So if you have an account at your local bank, you could just name your partner as the beneficiary of the account. So now if something happens to you, that money is accessible and is given to your partner. Again, it's easy to do. Usually there's no cost, no court involvement, and you maintain control while you're alive. Cons is that it's subject to your creditors, to your partner's creditors, can be spent frivolously. Partner can choose what happens to the remainder of the funds, and partner can only access at your death, which I don't know, maybe that's a good thing too. Okay, let's talk about wills and last will and testament. And now we're talking about using more of an instrument to be able to control the asset. So we could do a will, and we could at that point determine how the money's spent, who will get this thing. And then if there is any disagreement within the will, because a will has to go through probate for it to be effectuated and for it to actually, have the executor do what it's supposed to do, it is being overseen by the court process and by the judge. So you're a little bit more, maybe you're at ease knowing that what your wishes are truly going to happen. Cons: if you left outright money to your partner, again, so we have these creditor issue that, as you keep seeing on these slides, with the partner. So, I mean, you have your own creditors, and then a lot of times if you're adding them on an account on a property, then at the same time, now the same property is exposed to two sides, two creditors from each partner's side could be affected. If you leave it outright, you have no control over what happens to the remaining. So again, if you have children, or if you have other people that you want to make sure that you have your asset go to, your inheritance, you want to make sure they get it, then it becomes more difficult when you have a will, and if there's nothing in there that would dictate what happens to them at the time your partner passes away. Process will be overseen by the court probate, which, it was a good thing in the previous slide, a bad thing in this slide, because again, when we're talking about probate, we're talking about going to the court, we're talking about the long process, we're talking about the expenses that are associated with this process. So it's just in most cases not the best planning. The other thing with a will is it only applies at the time you pass away. So a will, you sign it, it gets witnessed, all the formalities, let's say you do, it doesn't mean it becomes effective now. It's effective at the time you pass away, which by just saying that, what that means is that you cannot do any incapacity planning within your will either, because if you're incapacitated, it's unfortunate. However, your will is still not effective because you're alive. So it lacks incapacity planning. All right, let's talk about the trust. Before I tell you about the trust, if you're enjoying this video, if you have a friend or family member that you think might enjoy watching this video, might get some information out of this thing and help him or her to do a better estate plan, please do me a favor and share the video or the link with them. I appreciate that. Let's talk about a revocable living trust. That's one of the kind of trusts that we could use within your estate plan. And what you can do is you can name your partner as the beneficiary within the trust. The good thing about a trust is that you can control what happens to the accounts and property. You can provide financial support even if you are incapacitated. Money and property given to the partner can be protected from partner's creditor. We could put it in a trust for your partner. And in most cases, there's no probate. As long as the trust has been done right, as long as you've transferred your asset within the trust, there's no probate. Within the trust, so I don't know if I have a slide. I don't. So let me tell you a little bit more here. So within these trusts, you have the person that creates the trust. They call that the grantor. That's you. Then you have, they call, sometimes you see trustors, trust makers, settlors, all these different names, 4 different names, all means the same thing, all refers to the same person, just there to confuse you more. But you're the person that created the trust. Then in most cases, you have the trustee being the grantor. So now you create the trust, and then at the same time, you hold this managerial position within the trust. They call them the trustee. And then you have this beneficiary within the trust. And I want you to bifurcate this beneficiary role, because in reality of it, there are 2 types of beneficiaries within each trust. You have a current beneficiary, and then you have a future beneficiary. So if you name your partner as the beneficiary of the trust, it doesn't mean that they're the beneficiary right now. If you name your children as a beneficiary, it doesn't mean they're the beneficiary right now. The current beneficiary of these revocable living trusts is you, the person that is creating the trust. You get to be the beneficiary. So as you can see, you created it, you play in that role. You're the manager of the trust. You're the beneficiary of the trust. You have the power to amend the trust, revoke the trust. You have all control. So when we do these type of trusts, when you transfer your real property in there, you would lose no control. You could do everything you were doing before. You could do a 1031 exchange. You could lease it. You could get a loan. And property taxes, especially if you're in California, property taxes do not reassess because you are still the beneficiary of the trust. And then within the trust, we could create it in such a way that we're creating continuing trust for beneficiaries. So if you want to do something that you want to provide for your partner, but at the same time, you don't want your partner to have the power to disinherit your children, what you can do is you can continue with a lifetime trust within your trust. So it says, at the time I, the grantor, partner number 1, pass away, whatever is left in my trust will stay within this lifetime trust for my partner. He or she can use the asset, they can live at the property. However, they cannot change any beneficiaries. And at the time my partner passes away, everything that is left will go to the children or people that you want to inherit your estate. You could do that. We could sort of do a variation of that and say, asset number 1 and 2 goes to the kids at the time partner 1 passes away. However, the rest, including the primary residence, stays within the trust for the partner's surviving partner to use. And then when he or she passes away, then at that point, everything goes to the kid. And then when we're talking about going to the children, we could draft the trust in such a way that you're not doing outright distribution to the kids, that you're creating a inheritance trust, or again, very similar to the lifetime trust. It's a continuing trust that you're placing these assets in there. It's usually a much better way for children to inherit, because the asset that is placed in these trusts at the time parent and partner and everybody passes away and now children are supposed to inherit, or your beneficiary, whoever it might be, it's given to them in such a way that if they run into trouble down the road, if they get in a lawsuit, they get in a divorce, they get in a bankruptcy, the assets that are within these continuing trusts that a parent or the initial partner had set up is completely protected against lawsuit, or at least it would be much more difficult for a creditor to try to take assets that are within those lawsuits if everything is done right. And so it's a great option. A lot of times we recommend it. That's how I have my own trust set up for my own family and my children. All right. Cons: a higher price. There is some set up. Sometimes people just are not familiar with trust, so some of the terms and initially maybe feels a little bit more difficult and a little more things to learn, but I promise you it's not too bad. Let's talk about additional tools for your toolkit. So we set up the trust. One of the other document that accompanies most of the time these kind of trusts is a pour over will. So even though we are using a trust as our initial and the main estate planning tool to avoid probate for revocable living trust in most cases, we still use a pour over will. And what it does is this pour over will, as its name suggests, it pours over whatever you have outside the trust into the trust. So now if you, for whatever reason, forgot to transfer your bank account in there, or you purchased a home and you forgot to get it transferred, then it pours everything into the trust. So then everything is administered under the terms of the trust. It doesn't happen automatically. So if you have, let's say, forgot to transfer your home in there, we still have to go to court. We still have to do a probate process. It's not the long and extended version of it, but still, especially here in California, Southern California, at least 3 or 4 months. So the main idea is that you set up the trust and then you transfer your asset or connect them in some shape or form to the trust. So now if something happens and you're not here, that we don't have to go to probate at all. The revocable living trust is named as a beneficiary of the pour over will, safety net to make sure everything gets into your trust, and it's managed based on the instructions and distributed based on the trust. All right, financial power of attorney. These become very important too. And you have these financial power of attorney. You select someone that's your agent to handle matters in case you're not able to do it. If you're incapacitated, you're not able to make mental decision. It's not physical incapacity, it's really mental incapacity. And so now you could have a limited power of attorney or a general financial power of attorney, and that really just talks about how much power you're providing to the agent. Then the other thing that you want to talk about or think about within these power of attorney is that when does it become effective? Is it effective right now when I sign it, or it's a springing sort of a financial power of attorney? And that means it doesn't spring up and down. It just means that its power, the agent's power, is given to him or her at the time some sort of event happened. And a lot of times that event within these sort of power of attorney is if you are incapacitated. You want to make sure that these financial power of attorney are durable power of attorney. And so let's talk about what that means. With these financial power of attorney, you could just have a regular financial power of attorney, and that means its power is effective until you are, if you're alive and you're fine and you're not incapacitated, this thing would work. As soon as you become incapacitated, if you have a regular financial power of attorney, it's not a valid document anymore. It doesn't have any power. If it's a durable power of attorney, what that means is that if the person, the principal, the person that created the power of attorney becomes incapacitated, this power of attorney will still be effective and allows the agent to do things on behalf of the person creating the financial power of attorney. And in most cases, in the type of work that we do in estate planning, you want it to be a durable power of attorney because in most cases, that's when these things are needed the most. If you don't name an agent, or let's say you have an agent, but that person has passed away or they're not willing to do, it doesn't mean the power of attorney becomes completely ineffective. It just means that we would have to go to court and have the judge select one. Again, it's not a bad option as the last resort, but the goal is to make sure we have someone that we trust and we know is that is named within the power of attorney. Medical power of attorney allows you to appoint trusted person to communicate, to make sure medical decisions for you are to make the medical decisions for you when you are unable to. And this really just means if there is no way you could communicate anything, if you could blink your eye and comprehend what they're saying to you, and you could say yes, no, that is sufficient, and you still are in control. These medical power of attorney usually are used if there's really no way to communicate. If you do not choose someone, the judge would choose one for you again. And then we talked about why we don't want that. With these power of attorneys, you have really two power of attorney that you want to have. The first one is California Advanced Healthcare Directive or Living Will. California does not have a living will. We use this Advanced Healthcare Directive. Allows you to have end of life decisions in there, instructions from you regarding medical decisions and all that stuff. This advanced healthcare directive allows the agent to make medical decisions for you. The other one, which is this HIPAA authorization form, this allows whoever you name on the form to receive medical information about you from the insurance company, from your doctor, from the hospital. As you could see, as an agent, you really need this document first to get the appropriate information, and then the other document, the advanced healthcare directive, so then you could make a better decision. All right, I think this is almost my last slide. Yeah, so let's take action today. If you are this far into this video, I'm sure you are in the midst of thinking about doing your estate plan, or you're looking to start to do your estate plan. I ask that you review your beneficiary designation forms. That becomes really important. If you have a partner, you want to maybe name them on the financial on these designation forms. If you don't have a trust yet. If you are creating a trust, then most likely what would be better is that we name the trust as the beneficiary. And then within the trust, we have indicated how the asset is to be kept and used and all that stuff. Review how your accounts and property are being owned, and give us a call. We'll love to talk with you, go over your estate planning if you have some. If you don't, we could talk about how we could set up the right estate plan for you and your partner and your family. You could visit my website, talailaw.com. You could give us a call. On the website, if you go, you could schedule a 15-minute call with me. There's no charge for the 15-minute call, and it's a good amount of time that I could kind of get an understanding of your situation and maybe try to see what works best. Do we need to do a full-on trust? Could we just have a will? Could we figure out another estate plan that would take care of your situation? All right, I hope you enjoyed this video, and I look forward to speaking with you on the next video. All right, take care.